Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration. Adjustment of status are 485, followed by a Q&A session. You can call the numbers displayed on the screen and ask any question related to immigration, and attorney will be glad to answer. We'll start taking calls in few minutes. Before starting the show, I would like to repeat or reiterate the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV News or agents are not responsible in any way for your actions. Please use the information at your own risk. Hi Prashanthi Garu, how are you doing?
Hello Ranjit, good thanks. How are you?
I'm good. Prashanthi Garu, today our topic is the adjustment of status or 485 application. So let's start with the basic question. What is difference between the filing and final action dates, and how does it work?
Right. So just to reiterate, last two sessions, we've been having this whole series of session on green card. We started with PERM, the labor cert, as to how to file it, what documents are needed, how much time it takes, etc., etc. Then we went on to the I-140. And in the I-140 session, we discussed the documents needed, the when cases get denied, on what basis they get denied. We talked about ability to pay. We talked about submitting proper documents with reference to experience letters, degree copies, etc. Then the last session, we started off with the 485, how to file, when to file, what things to keep in mind when filling out the form, what happens when there's a criminal charge. So basic, some of the information we covered, but we haven't finished the entire 485 topic. So this is part 2 of 485. And in this session, we'll basically cover frequently asked questions on 485, and we'll also cover what documents are needed to file a 485 and what to be careful about when submitting the documents, what to look for, and what are the traps usually with these documents when what the officer is looking for. So to answer your question, Ranjit, with reference to this is part of, when you can file a 485. So there are two dates for filing and final action date. So when you go to the visa bulletin, which is available on travel.gov, there's a visa bulletin for every month. And the visa bulletin usually comes out on the 15th or after of every month. Actually, January, it came out very quickly, the visa bulletin, surprisingly, but usually it comes out after the 15th. So the January 15th, you'll get the February visa bulletin. And from that visa bulletin, you will know whether the 485 can be filed or not filed, depending on, which category you're in. So there's so many different types of categories. Today, there's family-based, employment-based, diversity visa, religious worker, etc., etc. So EB5, which is investor visa. So we are mainly focusing on employment-based 485. So within that itself, again, that is EB2, EB3, EB1. So depending on what it says on your I-140 approval, it'll also say the type of category that you're in, and it will give you the priority date. So if that date is available, if they're working on that date, that means in the visa bulletin, then you can file your 485. Now, recently they have started two different tables. One is final action date, which has always been there. And the other new table that they started is dates for filing. So this dates for filing is simply when USCIS decides that you can use that table, they're allowing you to file in advance. So it's not that your actual date is available, but they're anticipating that it'll be available very soon. So they're allowing you to get the benefit of filing the 485. The benefit that you get is you can maintain status simply based on your 485. You can get employment authorization. You can change employers. You can get advance parole, which allows you to travel without a visa. So these are some of the benefits that you get from filing a 485. So they're giving you those benefits in advance. this is one way they are trying to compensate for people who have long waiting dates, especially Indian nationals with EB2, EB3, and EB1 categories. So that's something that they have, some way that they have manufactured that, allows some relief. So in October, the dates for filing became current. The dates for filing could be used, and the dates for filing are significantly ahead of the final action dates. So in October, we could use dates for filing. November also, we could use December as well. But in January, if you look at the visa bulletin now, we can no longer use dates for filing. So we go back to the final action date. So the final action date is the actual date. It's the date that you can file the green card and actually get it, and not just an advance filing. So the advantage of final action date is that, yes, you can get the green card in the next, 10 to 12 months if it remains current. And the other advantage, most important, is it locks the age of your child. So if your child is, say, going to turn 21 in 3 months, but you've already filed the 485, even if he turns 21, he or she continues to get the benefit of the 485 and will actually get the green card because the age freezes.
Yeah, Prashanthi, sorry to interrupt you. We have a caller, Praveen from New Jersey. Let's take the call and we can resume our discussion. Hi, Praveen. Welcome to the show. You are on the air. Please go ahead and ask your question.
Hey, hi, Ranjit. Hi, Prashanthi garu. I'm calling from a consulting firm, Andy. So I just have a couple of questions on the LCA.
Sure.
Hello. Yeah. So we recently had one of the RFEs where we opened an LCA for one of the H1B transfer. We mentioned as a new employee on the LCA, and we opened and we filed an H1B, which is a transfer. But we got an RFA stating that we cannot open as a new employee.
So you have two options in the LCA, and I don't have the LCA in front of me. But previously approved employment, so it's in an extension, you'll use previously approved employment. In a transfer, you'll use a new employer. So it is not incorrect.
Or change in employer.
Change in employer or new employer. Yeah, you can use both actually, and we've always alternatively used both. But I guess change in employer would be more correct when compared to new employer. New employer, I guess, would be in the case where, in cap cases when you're changing status from a H4 to an F1, or a H4 to a H1, or F1 to a H1. Otherwise, change in employer, this is the second time I've heard this actually, but otherwise in the past, we've used it alternatively and it has not really mattered. But now I guess they're
using as a new employment from past 4 years with what are the H1B transfers we are doing it. We never had an RFP, but this is the first time we had an RFP stating that we cannot use new employment. We have
it has to be change in employment, but I've never seen, and now that you're mentioning it, I've seen that I think RFE once before where they've said that. So in the RFE, I guess you need to respond, put your best foot forward. And, as USCIS keeps changing the interpretation of things, we have to change our practice also and put, I guess, change an employer instead of putting new employer. Now we know that, we've been doing that. We've been putting change in employer simply to avoid, unnecessary scrutiny and an RFE. So I think you should respond to it, saying that go back to the instructions in the LCA, if you can, and go back to filling out how to fill out the form, and go back to the I-129, how to fill out the form, and use that parallel in the LCA as well, and also point to previous LCAs that have been approved, and if there's been any change in policy, then that has to be in writing, and that you have to be notified of that before you can actually change something. So that's how I would go about responding to that RFE. Also, another way of doing it is if you have an already approved LCA and for change in employer, then you can use that as well if it's not being used right now. So those are the two things I would do in that situation.
Okay, I think you got your answer. Going back to our previous question, you were talking about, the importance of filing, using the filing dates, especially to protect the kids.
Yeah, so dates for final action are, that's why it's so important. Also, on a side note, the family-based immigration, if you look at the January visa bulletin, the dates for final action are actually ahead of dates for filing, and that happens sometimes. And if you look at permanent resident spouse petitions, they have actually become current, which is great news. So always be on the lookout for what the visa bulletin is saying, because it can change drastically at times.
Got it. So going to the next question, what is the I-485 fees, the first one, and what all other forms are filed with them and should be filed with them?
So 1225 is the fee, and it's 750 for dependents. So and if it's filed with the application, if the dependents are filed on their own, then again there's a separate fee. And this is all available on the USCIS website for you to look at, and you should look at it before sending out your application, because that fee keeps changing. The documents that can be filed with the 485 is the 765, which is the EAD. That's the benefit that you get, as I was saying, of filing a 485. And also the advance parole, which is the I-139. And Ranjit, if we have time, we can talk at length about advance parole, when it can be filed, and filing together, filing separately.
Sorry to interrupt you again, Prashanthi. I think the Praveen is back again. He got disconnected, it looks like. Yeah, Praveen, please ask your question.
I guess the call got disconnected. Sorry. So, Kashmir, my question is, because we have done that case in a regular processing, and after that we have done 2 H-1B transfers in a premium processing, and both were new employment, and we got those approved. So my question is, is that RFE depends on the officer? Because if it's an RFE, it should be RFE for everyone. If it's not an RFE, can we fight back stating that we had an approvals in the past, as we had new employment from past 4 years? We can take out all the cases and we can send them. Do you think, is that okay to respond in that way?
So first thing that you might know about USCIS, the most important thing is USCIS is never consistent with their decisions, right? One case will get approved with exactly the same facts, and then the next case, it will not get approved. So complete lack of consistency. So we can't expect that that's one thing. Second thing is, Ranjit, is my internet okay? Because
yeah, I think you're good.
Okay. The other thing is, yes, so one way of, and I suggested this, and maybe you got disconnected so you didn't hear, is to show them that in the past that they have always approved cases where you have given extension, or you've toggled between the two and it's never been an issue. And now if they're not approving it, or if they're changing their policy, then they should do so in writing and inform you of a change in policy, just to maintain consistency. So that would be a strong argument as well. But you don't want to give them every single receipt number, every single LCA, because you don't want them to then go back to those cases and deny every single one of them, or send out RFEs or notice of intent to revoke. So you're kind of playing with fire when you give them all that information. I would just say give them 1 or 2 cases and just say consistently, we've been doing this and we've never had an issue. And now you're saying that this is an issue. So I would do it that way. And as I said, another suggestion I had given you was, if you have LCAs approved for by putting the correct, change in employer, marking the correct column, then you can use those as well if they're not being used.
And also one more question on the same LCA, ma'am. So can you give me a little light on the concurrent H1? Can when same employer file a concurrent H1 for an existing employee? Like if an employee has a project at project A, and he has because things are remote and we had a remote project for him, can we file a concurrent H1 on the project B? if we can do it, because we already have one H1B which is active, and if you're doing a concurrent H1, and the thing is later on if the project A has been contract has been ended, can we still continue if we have approval on the concurrent H1?
So what you should do, so concurrent H1 is only filed when that person is working for another company, like company B part-time or something like that. That's a concurrent H1. You already have a H1 with your company. So it is not, it's not the right way of doing it. Instead, you should file a new LCA, right? And file an amended petition. So in the LCA, you would include both the work locations, the previous one as well as the new one. That's the way you should do it, not file a concurrent H1.
Okay, I think you got your answers. So yeah, going back to our previous question, we were talking about what all the forms we file with 485. That is, one is Advance Parole I-131, and the other one is I-765. That's for EAD. So apart from that, I believe there is also the public charge form still in place.
Right. So that's a big topic actually, and we didn't discuss that. Thanks for reminding me, Ranjit. The 944 is a huge topic. It can cover an entire session by itself. So while I-765 and I-131 is voluntary, meaning you can file it if you need it, and if you don't want to file it, you don't have to. But the form that they have introduced, and that was introduced in February 2019, I believe, is a new form, a new requirement, which on the basis of which your 485 can be denied, is the public charge requirement. Now, previously they had something called an affidavit of support, which is an I-864, but an affidavit of support was never needed for employment-based cases. It was only needed for family-based cases. Now they've introduced something called the 944, which is a public charge form, which is needed for both employment and family-based cases. So what this requirement basically is that you have to show that you have never been a public charge in the past, and you will not be a public charge anytime in the future as well, which means you have to show that you have a potential to earn and not be a public charge, and also that you have never taken public assistance in the past. So it's like a 10-page form with very detailed requirements with reference to have you ever taken any public assistance? Do you have health insurance, or have you had health insurance in the past? And there is a page where you have to mention your assets and your liabilities. So it's almost like taking a mortgage insurance, right? So if you have a certain asset and liability table and a certain formula for assets and liabilities. So if it's a certain percentage, then you get the mortgage, otherwise you don't. So it's the same thing. They want to see what is your assets versus your liabilities. And if they see the liabilities are more than the assets, then they can deny your case. So for example, if you have a mortgage, a house, you have to mention how much liability you have on the house. In addition to that, you have to mention how much money you have in the bank, and all that comes under the assets column. And then there's a liability column in which you have to mention what loans you have. If you have a car loan, a house loan, all these different types of loans, then you have to mention that. And then they look at the value of the house, and they put that under the asset. What is the actual value, market value of your house? How much did you buy it for? How much, So they go into that kind of detail with reference to what your assets and liabilities are. And then you have to produce documents. So for a 944, it's like an entire 485 application again, because it's like 400 pages of documents. You have to produce, you have to produce, then there's a question about your health insurance and your health benefits. What do you have? And then there's a question about your credit score. Do you have a credit score? If you don't, then give us proof that you don't have it. Run your credit numbers and from one of these websites and show us that there is no credit score. Or if you have a credit score, then give us the entire credit report for all your family members. So that itself is like 50, 60 pages. Then they ask for tax returns. So that, like 3 years of tax returns, that itself is like 200-300 pages.
I think there is also something called tax transcripts.
Yeah, so you can produce transcripts, and that will be less number of pages if you want to save on the pages. instead of submitting the entire tax return.
Yeah.
So
sorry to interrupt you, Prashanthi garu. We'll resume the discussion, but let's take a short break and we'll be back. Then we can resume the discussion. Let's take a break.
Reina Jewelry Boutique. Rediscover the princess within you. Customized 22 karat, 18 karat gold and diamond jewelry. Designer jewelry and sports jewelry made in 92.5 sterling silver. Available for purchase today. 100% certified jewelry. Contact us today for all your jewelry needs. Address 26 Rogan Drive, Harrington Park, New Jersey 07640 USA. Email rainaboutique@gmail.com. Call us on 1551-298-2184. Follow us on social media, Facebook and Instagram at Reina Boutique.
Okay, welcome back after the break. We have a caller, Prashanthi garu. Let's take the call. Hari from Texas. Hi, Hari. You're on the air. Please go ahead and ask your question.
Hi, ma'am. I'm calling from Texas, Dallas. I have applied H1B extension, but I got RFE, and the 240 days time is coming near. What is the 240 days rule? I have like RFE response time got extended for 60 days. It was previously 90 days due to this COVID. They extended 60 days. Is there any extension for 240 days rule, or how it will be?
So unfortunately, there's no extension for the 240-day rule. The 240-day rule simply says that you can work for a period of 240 days after you file the extension, even if your I-94 expires. But after 240 days, it's not like you're out of status. You're in status, but then you have to stop working. That's the main thing with the 240-day rule.
Okay.
And 240 days rule applies only with extensions. It doesn't apply for transfers. That's something that people don't often know. So it's only for extensions and not for transfers.
Not for transfer, only for extension. Okay.
Correct.
Okay, I think you got your answer. We have another caller, Arun. Let's take the call. Hi, Arun. Welcome to the show. You are on the air. Please go ahead and ask your question.
Yeah. Hi, this is Arun from Boston. So I have a question regarding my I-140 filing. So I got my H-1B approved in the year 2019. So my employer is planning to start the process for my I-140. Just I want to know the process and how the things. So would you suggest with EB2 or EB3? So can you please help me in that?
So, I mean, the process is you have to first file the labor cert, right? First is you have to file the perm, and then you can file the I-140. With reference to whether to do EB2 or EB3 right now, I mean, obviously EB3 is better. My suggestion is this, that you file the labor as EB2, meaning that you file for an advanced position if you qualify, like Masters +2 or Bachelor's +5. And then once you get the approval, then you can file the I-140. You can decide how you want to file it. You can maybe file for EB3 right now. But later on, you'll have the option of even filing a second I-140 for EB2 as well, as long as you qualify. So it's better to do it in an advanced position, and then you can file two I-140s, one for EB2 and EB3. If you do the labor for an EB3 position, which is just a bachelor's +2 years, then later on, if you want to do EB2 I-140 or change it to EB2 I-140, you cannot do it. You cannot upgrade, but you can downgrade. So better to file in an advanced position. And then you can downgrade to EB3 in the I-140 stage. So that's my suggestion for you.
Okay, thanks, Arun. Thanks for calling. Going back to our discussion, Prashanthi, we were talking about one of the important forms that has to be filed, that is I-944. I-944 has been, I'm in real pain, especially it has been struck down by court, then again they implemented, then again it's struck down by another court, then again it's being in place. So I know it's tough. So it's a lot of paperwork. So what happens if you are missing any couple of documents or some supporting documents with respect to I-944, and how mandatory all the documents you are talking are tax returns or maybe credit score, or sometimes the spouses don't have credit scores, or kids don't have. So how do you think this should be handled, and what are the important documents that needs to be in place?
So just to finish that form as to what they're asking, and then I'll answer your question. In addition to all this credit score, health insurance documents, etc., they also want to know what is the deductible for your health insurance, how high or how low the deductible is. So they're going into that much detail. And then if you don't have an I-140 of your own, like for the spouse, if they don't have their I-140 and they're depending on their husband's I-140, then you have to answer additional questions, such as, do you have then a degree? How marketable are you? Do you have just a high school diploma, or do you have a degree? Do you have a bachelor's? Do you have a master's? In what field? They're looking at all that to see. Yeah.
Sorry to interrupt you, Prashanthi. We have a caller, Sridhar.
Sure.
Hi, Sridhar. Welcome to the show. Please go ahead and ask your question.
Yeah. Hi, Prashanthi. How are you?
Hi. Good, thanks. How are you?
Yeah. Yeah, fine. Thank you. I have a small question. My wife is on H4, and we already filed adjustment of status in November. We received notices too. So I have a question. She's planning to go to India in month of February. Her H4 this I-539 is pending. If she gets EAD, once she has landed in India and she gets EAD, can she come back on EAD?
So is her advance parole approved? I missed that part.
No, her H4 is pending still.
Okay. So you filed a 485 for yourself and your spouse.
Yes.
Her H4 is pending. She wants to leave. If she leaves, how does she come back? So if you leave now, and if you file for advance parole, you might get biometrics when you're out of the country. And if you get biometrics and if you're not there, then that advance parole application gets denied. They will reject the advance parole form. So you will not get advance parole. So now the situation might be that she's out of the country. Then she can, if your H1 is continuing, that is, if you're continuing to maintain your H1 status even after getting the 485, or even after filing the 485, then at that point she can go for a H4 visa. Even if her H4 is pending here, that will automatically get cancelled. Then she doesn't have to wait for the H4. If you're out of the country anyway, that makes no difference whether she gets the H4, the I-797 or not. She'll have to go out of the country, get her a visa, and then come in on a I-94, which will be issued at the port of entry for her H4. So that will be issued for the period that you have your H1. So that will be the result if she leaves before her advance parole gets approved. If her advance parole gets approved and then she leaves, then she can return back on an advance parole and she can maintain her H4 status as well. Then she can just wait for her H4 I-797 to come in. It doesn't get cancelled automatically simply because she left the country, as long as it's not a change of status and it's just an extension. I hope that answers your question because I answered many different things. Hopefully that was not too confusing for you.
Yeah, thank you.
Yeah. Okay. So sorry, Prashanthi. So going back to our previous discussion, you were talking about sections in the I-944 that has to be minded.
Right. So I was saying that if you're a dependent and you don't have an I-140 approval of your own, they're then looking at how marketable you are, whether you're likely to become a public charge or not. Do you have a degree? Do you have, what kind of education do you have? Can you get a job? So the bottom line is, and then also they're asking are you a primary caregiver? So if you're a primary caregiver, there is some, I guess, concession. They're fine with you sitting at home and not doing any job. I guess there's some concession there. So the officer will look at the totality of the circumstances. He's going to look at the entire picture and see. And that's a little scary because it's very subjective then. Because there are no fixed parameters, right? It's up to the officer's discretion. So they can just deny it if they think that you're going to be a public judge. Because I don't think the parameters are defined well enough.
Prashanthi, sorry to interrupt you again. We have a caller, Avinash.
Sure.
Hi, Avinash. Welcome to the show. Please go ahead and ask your question.
Sure. I'm just trying to listen to the conversation. Thanks for the invitation.
You're welcome. So I guess Ranjit, he doesn't have a question.
Yeah. Please go ahead.
So with reference to the what you asked the I-944, and that was I didn't want to forget the question because that was a very relevant question. So basically, you are like, to what extent do we have to worry about this, and what documents does have to be submitted, and is it okay if we just send the form and not send any documents? Yeah, that's the approach that we were using. We were trying to send as many documents as possible with the 944 during the October rush, because it was really difficult to navigate that form and submit all the documents for a lot of people in that short period of time. Remember, we didn't have an entire month also, because by the time people realized it and started giving documents, really we had only 2 weeks. So what we were doing is as long as the form was properly filled out. Now, if the form is not properly filled out, if there is a blank, something that is not filled out or is left empty, then it's possible that the entire case can be rejected. So we were making sure that.
Okay. Sorry, Prashanthi garu.
Yeah.
We have a caller from DC. Let's take the call. Hi. Welcome to the show. Please go ahead and ask your question.
Hi. Can I talk to Attorney Prashanthi?
Yes, she is there. She's on air. Please go ahead.
Okay. I'm Sherry from DC. I'm an employer representing a small company. So I just wanted to understand, like recently there is a change in the wage levels, and the USCIS is going to change the process of the lottery as per the recent notification we have seen. So I just wanted to understand what would be the major changes they would do for this particular cap. And if at all there are going to be any major changes, what would be her advice based on her experience into immigration for the employers regarding the filings?
So you just asked the updates, the what we were going to cover in the updates after we finish the 485. So I will answer that now. We can cover that now. So there are obviously two regulations that you mentioned that are important for employers, for H-1B employers, that have already been published and will become effective in March. So one of them was changing the way the lottery is going to be conducted. It's no longer going to be random. And as of March 7th, I believe, or March 9th, that will become effective. And so what they're going to do is they're going to give first preference to jobs that have a higher wage. And then they're going to go down the line. So it's no longer random, just picked by, it's no longer computer generated. So and then the second.
I'm sorry to interrupt here. I have a question regarding the same. Do you advise the employer to go ahead and do the filing based on the level 3 wage, as like now the wages are going to be, it's be chosen on the wage levels?
So that's a good question, and I was going to say something which would answer your question. Having said that, it's going to be effective as of whatever March 9th or whatever it is, which is the cap season, right? They're just bang in the beginning of the next cap season. You also have to remember that two things. One is there will be a new administration from January 20th. So the new administration has already said that they will put a hold on all pending regulations. If the regulation has not yet been implemented, they said that they will put a hold on everything. There's a memo that has been issued. All regulations will be put on hold, and then there'll be a second look. So if the new Biden administration also decides to continue with the with this new registration rule, then yes, it will be implemented. The The second thing is, what happens is usually the OMB office can put a further 60-day, they can allow a further 60 days for comments, etc. If they're not sure about how constitutional the regulation is, they can have a second look at it. And that's not unusual. So that could, again, postpone it beyond the registration period, beyond the cap lottery period, and it will go into then May. So those two things could happen. So I would say just wait for now. In March, for sure, before the cap opens up, you will have a better idea as to what's going to happen. You will know that. So if it's going to be implemented, then yes, then the only way of circumventing this law and getting into the cap would be obviously to offer higher wages. Then you will have more chance of getting into the cap season. Level 4 is better than level 3, but just wait and watch for now. I would say don't make any decisions for now. Just wait and watch. We will have more clarity once the new administration takes over. And the same thing again with the wage level increasing. We know that they tried to do this previously in October. For the month of October, they had higher wages because they put in an interim regulation. And then we know what happened with the court cases. They put an injunction. 2 court cases in San Francisco. The court case, they basically completely removed it, and they said that this is ultra virus because the comment period, there was no notice and comment period. And then in New Jersey, the case filed in New Jersey, they put an injunction against it, and they're looking at the merits of the case. So both courts have decided that, this cannot proceed as of now. And so what the DOL has done is they have now they've put the regulation as they're supposed to, and they're waiting for 60 days for comments. But even that regulation, the memorandum that Biden administration has issued will stop that regulation. And then if the Biden administration decides that they should continue it, then they might. And then we have to contend with that as well. But I doubt it because I think the Biden administration will postpone that regulation because it's already in court. It's being decided by court. So though there is precedent to show that they don't have to go through the entire period, they can just implement the regulation again, because by going through court itself, they have given enough notice and comment. So again, with reference to both these, I would say to all the employees out there, wait and watch, don't make any decisions right now. Wait until the new administration comes in, we'll have more clarity then. And then we can, then you can make decisions as to what to do.
Okay, hope that answered your questions. We have another caller, Raja from Texas. Let's take the call. Hi, Raja. Welcome to the show. You're on the air. Please go ahead and ask your question.
Thank you. Good evening, ma'am. My question is exactly the topic which you are discussing, but I have a question related to H-1B work class kind of capacity of working H-1B. So can I volunteer to a different technical firm or another IT institution while I was on H-1B? That's my first question.
So I couldn't follow that because you were breaking up. Ranjit, did you hear it?
He's asking if he can be part of another company as a technical advisor or any kind of work when he's on H-1B.
Okay, so in order to work, for another employer, while you're on a H1 with employer A, if you want to work for employer B, we touched upon that. You have to file a concurrent H1. You cannot work otherwise.
I think he's talking about being part of the company.
So you can't. You can own. Well, see, this is tricky. So if you are trying to, you can be a passive investor in another company while you're on a H1, but you can't actually manage the day-to-day affairs of the company because then that would be working, and you cannot work without permission, without a H1. So you'll be violating your H1 status. But you can be a passive investor and then maybe you will have another person who's actually managing the company and who is a majority shareholder of the company. So there should be no, you should not be violating the laws, and also there should be no look of impropriety. It should not look as if you're violating it. So then, remember all the H-1Bs, for example, if you were to sign the forms on a H-1B, or if you're handling all the affairs and your email is out there, then, if there is an audit on the H-1, the first thing that they will ask is who is the signator, and that they want to talk to the signator. So you have to be careful. And if they find out, the first thing they'll ask is, what is your status? So as I said, you can be a passive investor, you can own shares in any company, in Microsoft, or if it's XYZ company, but you cannot actually run the day-to-day business of the company. I hope that was your question and it got answered.
Yeah, Prashanthi garu, going back to your topic, again, the 944, we are still there. So yeah, could you please extend the topic?
Yes. So I think I was discussing the 944 as to how marketable a person is when they don't have their I-140 and their dependents, and how we said that if you're a caregiver, maybe the scrutiny will be less if you can show that there's children and you're the person who's taking care of the children at home. So I was also saying that the overall, they'll look at the overall picture, and then the officer will decide whether you are eligible for the green card or not, which is a little scary. That's what I was saying. I think I was also saying that with reference to your question, that during the October time, because we were rushed, a lot of attorneys, I think what they were focusing on more is whether the form was filled out correctly or not. And we were submitting as much documentation as we could, and some clients were very good in providing documentation, those hundreds of pages of documents, and we submitted everything. But in some instances, we had very skeleton documents, like only their tax returns. Maybe they didn't run the credit report. As you said, for dependents, some of them were not able to show that they didn't have a credit score. They were not able to figure out how to do that. And some of them were able to do it. So we submitted as much documentation as we could. I was not very concerned about the supporting documents and looking into the actual merits of this whole public charge, because it's in court, and the court has already struck it down once. So, and then the other court passed an injunction in some states. So in some states, it's not even valid. In some states, it is. So keeping in mind all this, I would not be overly concerned right now about submitting every single document. What I would say is submit, and also they will look at this at the time of the interview. And most probably they will ask for more documents, or they will ask for updated for documents. So I wouldn't be too worried about the supporting documents. I would for sure submit the form and make sure that it's accurate, and then submit as much as you can, and not worry about this at this point. Once it does become a law for sure, then I would take it more seriously. But for now, just submit the forms, and make sure the forms are accurate. That is very important, because if there's something that's not filled out in that 944 or in the 485, that could come back, and that's another topic to discuss as well, Ranjit. As to what happens
we have Prashanthi, we have a few callers. Let's take one call. Ajay, please go ahead and ask your question. You are on the air.
Hi, ma'am. This is Ajay. I have a question regarding my I-140 process. So recently, I filed my I-140 on 2020 of July and July 28th of 2020. So still I didn't got my perm approved. So usually, how many days will it take for approving the perm, and what will be the process next process for the I-140?
So you're saying you filed your labor, not the I-140. You filed the labor in July of 2020, correct?
Yeah. Yes,
okay.
ma'am.
So it usually takes about 6 to 8 months for the labor to get approved. But you have to remember that a lot of labor certs are being audited during the COVID time, because the Labor Department has specifically been, they always do that. Whenever the economy is not good, they tend to increase the number of audits. So we are seeing audits, and the audits are basically, they're asking for recruitment information. So they want to make sure that all the ads have been placed properly. They're asking for business necessity documentation. So they want to make sure that if you've asked, if for example, you're saying you're a systems analyst and you've filed an EB2, they want to know on what basis you're filed on EB2, because the general requirement for a systems analyst is, EB3. But it's not that you can't file EB2, but you have to show that an advanced degree is required. So you have to show explanation of that as to how the complexity of the duties, etc. They're also asking for if you've received any resumes and if you have actually disqualified them correctly. They're asking for the recruitment report. And they're asking if your employer has required some skill sets like C, C++, some kind of language or some databases in the IT context. They're asking why those skills could not have been learned once you joined the employer. Why does he require to have them before? So you have to show that it's expensive to learn those skills. It takes a long period of time to learn those skills. So these are basically the what they're asking in the audits. And when there's an audit, usually your time frame increases, and it could take up to a year, because once there's an audit, then again they have to look at the documents, review. So if no audit, 6 to 8 months. Otherwise, it could take a little longer, maybe 10 months to 12 months.
Yep, sounds good. So we have another caller, Praveen from Canada. Let's take the call. Hi, Praveen. Welcome to the show. Please go ahead and ask your question.
Yeah. Hi, ma'am. It's Praveen here. I'm actually from Connecticut, not from Canada. Okay, my question here is, I have applied for my from H4 to H1, where I have not utilized my H1 in the past entire 6 years. So I've got 3 years balance with me. So based on that, I've applied for the converting from or transferring from H4 to H1. But then recently I got a message from USCIS saying that they are sending me an RFE. So I'm a little bit concerned, what could be the RFE and how do I respond?
So that is a very broad question. We don't know what the RFE could be. That's like speculation, right? You're asking me to speculate, which I don't know. So I'm not concerned about the factors that you mentioned with reference to change of status. I mean, as long as you're in status and you maintain your H4, the change of status is not an issue. As long as you were previously on a H1, changing from H4 to H1 is not an issue. You don't have to wait for the cap. It could be anything. It could be the usual problems are specialty occupation. That's one big issue. It could be they want documentation from your employer. The vibe issues. Vibe is basically, if your employer is not registered on the Dun & Bradstreet website, they can't verify that your employer is a valid entity. And they ask for all kinds of documents. They ask for tax returns. They ask for registration documents, lease, etc., etc. So these are a few of the common reasons for an RFE. Specialty occupation, number one, that's the biggest reason. Right to control used to be a big reason. It no longer is, thankfully. They might ask you to show that you maintained H4 status in the past and to show that your spouse is on valid H1. And they might ask for pay stubs if your spouse. That's another reason why they could send an RFE. That's quite common when you're filing for change of status and you haven't enclosed, for example, the latest pay stubs of your spouse or a marriage certificate to show that you are related. So these are some of the reasons why you could get an RFE. It could be a completely different reason as well, unpredictable reason, but these are the usual reasons.
Okay, hope that answered your question. We have another caller, Ajay from Virginia. Hi, welcome to the show. Please go ahead and ask your question.
Yeah, hi ma'am. This is Ajay. Just now I called you regarding the I-140, right? My call got disconnected. Sorry for that.
Yes.
I have follow-up question for that. The thing is, my labor certificate is still taking a lot of time, right? So the other thing is my H1 of 6 years is going to end in 2020 October. So will be a problem? So my main question is like my I-140 will gonna approve before that, or like if it doesn't approve, what will be the process?
Right, that is a good point, which we didn't discuss. So even if the labor gets approved by July, giving it a year, which is reasonable, and then the I-140, remember you have premium processing, which is good. So it could even get approved within a month or maximum 2 months. So I think you should still be okay if you have your H1 until October. But in case it doesn't for some reason and it gets stuck at the labor or the I-140 stage, then you can apply for time that you spent outside the country. That's one way, recapturing time spent outside the country and filing an extension for a further month or 2 months or 3 months. Whatever time you have left. If you have used that time as well, then my suggestion is to file for a change of status, to a different status, and then come back to a H1 once your I-140 is approved. Or you can leave the country for a period of time and come back on the H1 once your I-140 is approved. So these are some of the ways that people usually deal with this situation.
Okay, I hope that answered your question. There's another caller, Siddharth. Hi, Siddharth. Welcome to the show. Please go ahead and ask your question.
Hey, Prashanthi. Good evening. How are you?
Hi, good. Thanks, Siddharth.
That's great. Prashanthi, this question is we have a consulting company in Texas, and we get a lot of profile stating many consultants states that when they have entered into US, they started their career into day one CPT. So now if they get a job and if we apply for a H1B, do we get any kind of problems when we are applying for H1B? Because tentatively, I don't know how legally is valid. If a person comes on a F1 visa and states that he's working on day one CPT, so is it valid that people can work on day one CPT?
So that's a very good question, and we're getting a lot of good questions today, which is relevant to a lot of people. So day one CPT has always been an issue. Whenever you file a change of status from an F to a H, and it's very common also. Because people, if they're not getting into the cap, the first time they try, the second time they try, then they transfer to another school, do another degree, but they have to keep their job, so they do take day one CPT. This is unfortunately how the system is, and simply because of the cap situation and the numbers that are available, the scarcity in numbers. So to answer your question, day one CPT is not disallowed. It's allowed. It's not against the law as yet, until they make it so. Then they have to publish a regulation for that. And it has to, go through the courts and stuff, because there will be litigation if they publish such a regulation. So, it has to go through Congress, and then the courts can't say anything, So as of now, the situation is that as long as the university justifies why CPT is required on day one. There are a lot of universities, like Campbell and some other universities, where they offer executive master's programs, which basically means that the way the course is structured is that, practical training, you have to get practical training and theoretical training side by side. That's how the course is structured. So that's how a lot of the day one CPT courses are justified. And so as long as it's justified, as long as they can show that the CPT is an integral and essential part of the course curriculum, day one CPTs are fine. Do you get an RFE? Yes, most probably for every single change of status. Most of them, when you do an F1 to H1, this is the question with reference to OPT status and CPT status is always asked. But a more important thing, I think, with reference to CPT is that when they say day one CPT is fine, you can respond to that, and most of them are getting approved. But when they say that you have used 1 year of OPT, and then in addition to that, you're using CPT, that's a more dangerous question when you get that in the RFE, because they're not approving those cases. So they're saying that only 1 year of OPT is allowed as per the law, and so CPT is considered as OPT, even though it's, they've extended the law. So unless you go to court and fight them out, that seems to be the situation. So you have to be careful with that scenario. When they have been on OPTs for 1 year or whatever, the 3 years, and then again went to CPT, that I think is more problematic than just the day one CPT.
Okay, that answers the question. So I think we are towards the end of the show. Before I end the show, I just want to repeat the disclaimer. Please note, this show does not provide any legal advice. It is very general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible for any way for your actions. Use this information at your own risk. And if you would like to reach the attorney Prashanthi Garu for a private consultation, please reach at 212-354-1010 or prashanthi@reddyesq.com. Before ending the show, I just want to ask one question. A lot of people have not got receipts yet. So is there anything to be worried?
Yes, that is the question of the hour. And I get so many phone calls every day from worried clients. What we have noticed is that, especially in Texas Service Center, where most of the cases were filed, no receipts have been received. And this is across the board and with many other attorneys as well, because we all talk with each other. After October 26th, we have really not received any receipts. And also with reference to cases that have been filed downgrade, I-140 and 485 together, we've received very few receipts for those as well. The cases that were filed before the 26th, especially in the first 2 weeks of October, some of them have received advanced parole and EAD as well, and biometrics. So there is a disparity. And also the ones that have gone to the National Benefit Center,
Okay,
the MSc.
Prashanthi, sorry to interrupt you. I think we are already towards the end of the show. We can discuss more in the next session. Thanks for all the calls and watching this. So it was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday 5:30 p.m. EST and Sakshi TV. This is Ranjit signing off. Thanks, Prashanthi.